Thank you, Mark Cunliffe, Chris Hanna, for the invitation to be here at Defense Legal. It's a great honor for me. Professor Oswald made reference to Sir Ninian Stephen, and I want to pay tribute to him as well. Sir Ninian was a judge on the International Criminal Tribunal for the former Yugoslavia when I was posted to The Hague as legal counselor at the US Embassy in the mid-90s, and I had the opportunity to work with him and to deal with him in various ways at that time. And it's a true honor for me to be delivering this lecture in his honor. I also want to thank the Asia Pacific Center for Military Law, which has brought me here, and in particular its director, Professor Oswald. I've known Professor Oswald now for more than a decade. He and I have had an ongoing discussion about IHL issues during that time. I always come away from those discussions better informed than I started. And I'm very grateful to him for inviting me here, and we've been able to continue that collaboration while I've been here for the past week or so. I also want here at the Department of Defense in particular, to pay tribute to the Australian peacekeepers. In 1947, Australians were part of the very first group of UN military observers being deployed to Indonesia. Australia has been a pioneer in peacekeeping with the UN as UN peacekeeping has evolved over the decades. Australians have been involved in many peacekeeping operations, including those in Cambodia, Somalia, Rwanda, Iraq, Papua New Guinea, East Timor, South Sudan, Middle East, and Cyprus. And 16 Australian nationals have lost their lives during peacekeeping operations. This afternoon, I'm going to discuss 3 legal issues that arise in connection with contemporary peacekeeping. First, I'm going to talk about the humanitarian law implications of robust peacekeeping. Then I'm going to touch briefly on some issues related to international responsibility. And finally, I'm going to talk about some issues related to sexual exploitation and abuse, what we call SEA. Before I do so, though, I'd like to briefly discuss the evolution of US peacekeeping and how and why UN peacekeeping has evolved from its traditional model to the more robust model we see today. I'm sure it's well known to those in this room that peacekeeping is not mentioned in the UN Charter, and it was an innovation of some of the early Secretaries General and the principal organs, the Security Council primarily, but on occasion also the General Assembly. One could take the view that UN peacekeeping emerged out of necessity, allowing the organization to address challenges that it would have been otherwise unable to address, because the military arrangements that were contemplated by the UN Charter were never able to be brought into play. Secretary General Dag Hammarskjöld is in some way the father of peacekeeping, and it's to him, I think, that we can credit the early articulation of peacekeeping doctrine. In his period, peacekeeping evolved from unarmed military observer missions to the first armed peacekeeping operations with a limited mandate to use force. And we have seen since his time the development of more recent multi-dimensional peacekeeping operations with broader authorities to use force. The exclusive UN chain of command and control was also established in the regulations issued by Secretary General Hammarskjöld for the UN Emergency Force 1, which confirmed the full command authority and operational responsibility of the UNEF 1 force commander, while the Secretary General retained authority for all administrative, executive, and financial matters, and for the negotiation and conclusions of agreements with governments. The Secretary General also channeled all instructions from the UN principal organs to the force commander and the chain of command designated by him. As many of you will be aware, the traditional model of peacekeeping was premised on three cardinal principles: consent of the parties, impartiality, and the non-use of force in self-defense. That third principle, the non-use of force except in self-defense, has since been extended to encompass the use of force in defense of the mandate. Starting with the UN mission in Sierra Leone, UNAMSIL, which was established in 1999, the Security Council began to routinely include language in the resolutions providing the mandates of the missions to protect civilians, a so-called protection of civilian mandates, POC mandates. Now, this was not entirely a novel approach. Already in 1960, an operational directive issued for the UN operation in the Congo, ONUC, provided that, and I'm quoting, "where feasible, every protection will be afforded to unarmed groups who may be subjected by any armed party to acts of violence likely to lead to loss of life," unquote. And the operational directive concluded, quote, "in such cases, UN troops will interpose themselves, using armed force if necessary, to prevent such loss of life," end of quote. And other missions had also had some mandate to protect civilians. But the standard introduction of more robust POC mandates by the Security Council from 1999 onwards reflects a few developments. One, the increasingly internal nature of the conflicts, in which civilians have become the principal victims. This increase in the number of internal conflicts has also prompted a broader range of activities entrusted to UN peacekeepers, including the protection of safe areas and support for the delivery of humanitarian assistance. I think to some extent one could say that the more robust peacekeeping mandates of the current generation of peacekeeping missions reflects a continuing attempt to build upon the difficult experiences of the UN missions in Rwanda and Bosnia-Herzegovina in the mid-1990s. Whether the robust POC mandates have been accompanied by an actual increased capacity to effectively protect civilians at risk is a matter of debate. Among the factors that will affect delivery of such mandates are the available resources, the mobility of the UN troops, and the extent of their deployment over large swaths of territory. Also among the relevant factors is the provision by contributing countries of well-equipped soldiers ready and willing to confront spoilers, including armed groups and even national authorities who are threatening civilians. We've also seen in the UN mission in South Sudan the emergence of a more passive concept of protection of civilians, in which civilians have been provided safe haven in UN camps. And there is some thought that this may become a norm, particularly in hostile and complex situations. It must be noted, however, that even in the protection of civilian sites in South Sudan, in some cases these camps have been attacked by armed groups in circumstances in which the United Nations was not able to protect them effectively. UN peacekeeping operations are also increasingly deployed in contexts where there is no peace to be kept, and thus they find themselves increasingly targeted and drawn into conflict. The situations in Mali and the Central African Republic come to mind. And it appears that the armed groups in those countries have no interest in a peace process or in helping to create conditions for development of those countries. Now, by virtue of the mandates that the peacekeeping missions in Mali and the Central African Republic have, which include supporting the state in reasserting its authority over part of the territory, and sometimes most of the territory, a question can also be raised whether the traditional concept of impartiality applies with respect to the UN's role vis-a-vis the non-state actors in those countries. Not surprisingly, the increasingly robust mandates of UN peacekeeping missions and their frequent involvement in the midst of hostilities in recent years has generated debates on the application of IHL to UN peacekeeping operations. And I'm going to turn now to that issue. The question whether IHL applied to UN peacekeeping operations in the first place was debated for many years, and this initial question arose because the UN is not a party to any of the principal instruments in IHL, and also because those instruments, for the most part, do not address peacekeeping at all. Peacekeeping postdated many of those instruments. That broad issue, though, of whether the UN regards itself as bound to observe the norms of IHL was, for the most part, addressed by a bulletin issued by the Secretary General in 1999 on the observance by UN forces of IHL, which sets forth in an abridged form most of the principal rules of IHL and indicates that the UN peacekeeping personnel will comply with those rules. However, there are some particular issues of how IHL applies to UN peacekeeping operations in particular cases, which continue to be open, and I'm going to discuss one of those, which is whether there are circumstances in which a UN peacekeeping operation can itself be considered as a party to an armed conflict. This question should be approached with caution, as the circumstances in which a peacekeeping mission may become involved in an armed conflict varies. And in many questions, even though UN peacekeepers are deployed on a mission in which an armed conflict is taking place, the question whether the mission has become a party to an armed conflict has not arisen. Particularly since the 1990s, however, peacekeeping operations have been attacked and been compelled to react by force, particularly against armed groups, either in the exercise of their right of self-defense or pursuant to a Security Council mandate to take all necessary measures, perhaps to protect the civilian population. Attacks against UN peacekeepers have occurred, for example, as part of carjackings, robberies, office break-ins. Those things would not normally be regarded as situations of armed conflict, and I don't think they pose in any serious way a difficult question about whether the UN has become a party to an armed conflict by using some force in responding to that type of situation. But there are cases in which the UN has a mandate to use force for offensive purposes, and I think those cases raise a particular issue of whether the UN could become a party to the conflict in those cases. And perhaps the clearest example of this is in relation to MONUSCO, the UN peacekeeping operation in the Democratic Republic of the Congo, and that mission was authorized by the Security Council to carry out targeted offensive operations through its intervention brigade to neutralize armed groups. And in fact, pursuant to this mandate, MONUSCO did carry out combat operations against the M23 between August and November 2013, often in support of military operations carried out by the DRC armed forces. And in this instance, it was argued, including by the ICRC, that MONUSCO had become a party to an armed conflict in the DRC. Some members of the Security Council at that time sought to draw a distinction between the actions of the intervention brigade and the other military units of MONUSCO, and we can consider later whether that distinction has any merit. There's another context in which the question of whether a UN peacekeeping mission could become a party to a conflict has arisen, and that has to do with the cases in which the peacekeeping mission is providing support to government forces, and whether the mere provision of support could be viewed as causing the UN to be regarded as a party to the conflict. For example, in the peacekeeping operation in Mali, MINUSMA has in the past shared intelligence and conducted joint patrols with the French forces who are deployed there pursuant to a Security Council mandate. And so it's been argued in that context that the support provided by MINUSMA could make the mission a party to an armed conflict. I think the view that the UN lawyers at least have taken to this point is that it's not clear to us whether support to government forces alone without direct armed clashes with armed groups would make a peacekeeping mission a party to an armed conflict. Now, why does this issue matter so much? I think the particular concern for UN member states, and in particular many of the member states like Australia that contribute peacekeeping forces, although I'm not aware that Australia itself has a strong position on this issue, but some of the traditional peacekeeping partners do. Their concern is that if a peacekeeping mission becomes a party to an armed conflict, the military personnel of that mission will lose the protection from attacks and become lawful targets. They see the prospect of the mission becoming a party to a conflict also endangering the civilian personnel in peacekeeping missions, as well as anyone seeking protection in such missions. So we'll now try to drill down a bit on this question of what would be the consequences of a UN peacekeeping mission becoming a party to an armed conflict. It's widely accepted that personnel of peacekeeping missions are generally to be treated as civilians and to be protected as such under IHL. Therefore, peacekeeping mission personnel are protected from attacks, and parties to the conflict are required not to direct attacks against UN peacekeepers. But there is in the Rome Statute and elsewhere an exception for cases in which peacekeepers lose the protection that is accorded to civilians. As UN peacekeeping operations have become increasingly involved in hostilities, the following argument has been made, including by the ICRC. When a peacekeeping mission engages in military operations, it becomes a party to an armed conflict on the same basis as any other armed force. Once it becomes a party to an armed conflict, all military personnel would collectively lose the protection given to civilians under IHL until the end of the armed conflict. So according to some who take this approach, all military personnel of such a mission could be targeted lawfully wherever they are in the host state's territory, even if they're located far away from the place where the hostilities are taking place. Furthermore, all military personnel of the mission could be lawfully targeted even if they're carrying out activities that have no connection with the hostilities. And one can imagine, for example, a situation in which peacekeepers are assisting in the delivery of humanitarian assistance. And this approach also would suggest that the military personnel would remain lawful targets until the end of the armed conflict, which could be many years later. Now, on the other hand, some authorities, and in particular representatives in New York of some of the states that contribute peacekeepers to UN missions, have taken the view that UN peacekeepers acting under a lawful mandate of the Security Council should never be regarded to parties to a conflict, or should never lose the protection that they generally enjoy. Now, this issue remains unresolved at present. It has been addressed in a few cases by international courts, particularly by the Special Court for Sierra Leone and the International Criminal Court. In the Sese case, the Special Court for Sierra Leone examined a number of incidents that occurred in 2000 in which the Revolutionary United Front, the RUF, an armed group in Sierra Leone, ill-treated, captured and attacked a number of military personnel of the UN mission in Sierra Leone. The court first stated that the personnel of peacekeeping missions are entitled to protection, but will lose that protection if they take a direct part in military operations. The court also stated, and I quote, "Where peacekeepers become combatants, they can be legitimate targets for the extent of their participation in accordance with international humanitarian law." End of quote. Now, in this particular case, the court found that the UN personnel were not taking a direct part in hostilities, and therefore the attacks against them were considered to be a crime. But you see that the possibility of UN personnel becoming lawful targets was entertained by the special court. The International Criminal Court has also dealt with the issue on a preliminary basis in the Abu Garda case and the Banda and Jerabo case, although these cases involved African Union peacekeepers rather than UN peacekeepers. In these cases, the court dealt with an incident in which armed groups in Darfur directed an attack against an AU mission in Sudan in 2007. And the ICC took a similar approach to the Special Court for Sierra Leone and stated that, I'm quoting, "Personnel involved in peacekeeping missions enjoy protection from attacks unless and for such time as they take a direct part in hostilities or in combat-related activities." End of quote. And in this case, the ICC found that the AU personnel did not take any direct part in hostilities and that there were substantial grounds to believe that they were entitled to the protection given to civilians under IHL. So what can we draw from these few cases? First, it seems that these courts have taken the approach that peacekeeping personnel would lose the protection given to civilians under IHL on an individual basis rather than collectively. In other words, only those individuals who are directly engaged in military operations would become lawful targets, while others would continue to be protected. And these cases also seem to indicate that while the personnel would become lawful targets only for such time as they are taking a direct part in hostilities, and that they would retain their protection outside that specific time frame during which they're engaged in hostilities. And this is in marked contrast to the approach that personnel would lose the protection on a permanent basis until the end of an armed conflict. So I'm going to stop there on that particular topic. I think you see that the case law is heading in a direction which would not be the doctrinally pure position perhaps suggested by the ICRC, but a standard that is perhaps more appropriate for the specific nature of peacekeepers and the idea that peacekeepers should only become lawful targets for the period in which they are engaging directly in hostilities. I'm now going to move to my second subject, which is the responsibility of the UN and of other international organizations for peacekeepers, and a couple of issues that arise in the context of not peacekeeping operations and UN support for non-UN security forces. So first, I'm going to touch briefly on the potential responsibility of the UN for acts of its peacekeeping missions or acts of forces supported by the UN. The UN Secretariat has taken the position that as a general matter, when a UN peacekeeping operation is under UN command and control and is engaged in military operations in an armed conflict, the UN is responsible for violations of IHL committed by the members of that mission, even though those members of the mission are also members of a specific national contingent. However, as UN peacekeeping missions consist of troops contributed by member states, the question has arisen whether the troop contributing countries could also be responsible for the acts of their troops serving in UN peacekeeping missions. And this issue has arisen recently in the Netherlands, in the courts there. The courts have examined certain actions carried out by the Dutch battalion while it was serving in the UN peacekeeping mission in the former Yugoslavia in the 1990s, and the courts examined whether the Netherlands was responsible for the deaths of 3 persons who were asked by the Dutch battalion to leave the Dutch compound in Srebrenica, and who were subsequently killed by the Bosnian Serb forces. And in this case, the Supreme Court of the Netherlands ruled that the Netherlands had effective control over the Dutch battalion, and that it therefore was responsible for the deaths of the individuals concerned. So this case illustrates that not all actions by troops serving in a UN peacekeeping operation will be attributable to the UN, and that certain specific actions could be attributed to states, either individually or jointly with the UN. It also illustrates, I think, that the question of attribution has to be approached on a case-by-case basis, and the facts of each specific case need to be very carefully assessed. I mentioned earlier that one of the roles of UN peacekeeping missions and these multi-dimensional missions that now exist is to provide support to non-UN government-led security forces. And this has raised the question of to what extent should UN support be provided to security forces that may engage in violations of human rights, international humanitarian law, or in other acts that would be considered internationally wrongful. The legal framework for assessing the responsibility of international organizations is still being developed, but there are draft articles prepared by the International Law Commission which provide that an international organization that aids or assists, those are the key words, aids or assists, a state or another international organization in the commission of an internationally wrongful act by that state or the latter organization is internationally responsible for doing so if the organization does so with knowledge of the circumstances of the internationally wrongful act, and if the act would be wrongful if committed by the organization. Now let me give you an example of what I mean. This issue arose for the UN initially and somewhat dramatically in 2009 in the Democratic Republic of Congo, when the then UN mission there, which was called MONUC, was faced with the dilemma of whether to continue assisting the government-led forces, the FARDC, in their military operations against armed groups in North Kivu, as mandated by the Security Council to do so, or whether the UN should decline to provide such support based on an expectation that in the course of such UN-assisted operations, the government forces would be likely to commit serious violations of international human rights law and international humanitarian law against the civilian population, whose protection had also been mandated by the Security Council. In October of 2009, the legal counsel of the UN opined that if MONUC, the UN mission, had reason to believe that the FARDC units were involved in an operation involving violations of international human rights or international humanitarian law, and if MONUC, in interceding with the FARDC and with the government of the DRC, if they were unsuccessful in addressing this, then, and I'm quoting from the legal opinion of the legal counsel, MONUC may not lawfully continue to support that operation, but must cease its participation completely. End of quote. So upon this advice of the legal counsel, the Security Council adopted a policy conditioning the UN assistance to Congolese troops on their respect for human rights and international humanitarian law. And this MONUC precedent informed then the development of a broader doctrine called the Human Rights Due Diligence Policy on UN support to non-UN security forces, formally promulgated in 2013. And this policy sets out measures that all UN entities must take in order to ensure that any support that they may provide to non-UN forces is consistent with the purposes and principles of the UN as set out in the Charter, and with the UN's responsibility to respect, promote, and encourage respect for international humanitarian, human rights, and refugee law. Now, as I said, the legal framework is still somewhat unclear for what would be required in order to find that the UN or any other international organization had aided or assisted a state or international organization in committing an internationally wrongful act. One would need to look, I think, in a very careful way at what support was being provided and at what knowledge the organization providing the support had concerning the commission of the wrongful act. But I think it's important to be aware that support can potentially provide the basis for international responsibility. Now I'm going to turn to the last of the three topics that I'm discussing, and this is the very vexing issue of sexual exploitation and abuse. It's understood, I think, that the peacekeepers that the UN sends into the field in very difficult situations have to make great personal sacrifices to be there, and they take important risks to support the UN's peace efforts. But tragically, some of the individuals that the UN and its member states have entrusted with these critical tasks have failed to be worthy of that trust. And although these individuals have been deployed to keep the peace, they instead have violated the persons and dignity of beneficiaries of UN assistance by engaging in acts of sexual exploitation and abuse against them. The uproar generated by incidents of peacekeepers committing sexual violence against those they have been sent to protect has prompted many reforms at the United Nations in the past 15 years. Despite sustained efforts since 2002, when there was a crisis in the wake of widespread allegations of sexual exploitation and abuse in refugee camps in West Africa, addressing sexual exploitation and abuse remains a persistent and complex challenge at the UN. And I'll address today three specific aspects of that. First, what are the root causes of sexual exploitation and abuse in the UN context? Second, why is it difficult to prosecute criminal acts of sexual exploitation and abuse? And then third, what are the most recent actions taken by the Secretary General to improve the UN's response to sexual exploitation and abuse? So, at the outset, it might be helpful to explain briefly what the UN means when it refers to sexual exploitation and abuse, or what we call SEA. Sexual abuse means rape and other forms of sexual assault. Sexual exploitation means the abuse of a position of vulnerability, differential power, or trust for sexual purposes, including but not limited to the exchange of money, employment, goods, or services for sex, as well as any exchange of assistance that is due to beneficiaries of UN assistance for sexual purposes. Now, issues concerning SEA are not limited to the UN, but it seems to us that there are some specific contexts, specific aspects of the context in which the UN is operating that makes it perhaps more likely to occur in UN operations. These have to do with the fragility of the states in which the UN is frequently acting and the highly vulnerable populations there. The states in which the UN is deployed are generally fragile because their institutions have usually been shattered by several years of armed conflict. As a result, the governmental institutions might not be fully functioning and operational. Inter-ethnic tensions may be detrimentally affecting their work. Armed conflicts also often have a devastating effect on the state's economies, which are sometimes in shambles and need to be rebuilt. The populations of these states are also highly vulnerable because many are struggling to survive in a conflict or post-conflict setting, often with little to no education or income, in situations of extreme poverty. Orphaned children and persons with disabilities are even more vulnerable in these precarious circumstances. In some cases, years of conflict and famine have further increased the vulnerability of local populations by displacing tens of thousands of them, often without adequate protection. Without resources, without employment, the local population, including children, may become reliant on outside assistance and feel that they're compelled to do whatever they need to do to sustain themselves and their family. They therefore can become prey to sexual exploitation. Without adequate safety and security systems in place, they are also at an increased risk of becoming victims of sexual abuse. A number of additional factors may exacerbate the risks of SEA by UN forces, including the duration of the mission, the number and type of interactions with the local population, the intensity of the conflict, and the remoteness of the areas in which the UN offices or compounds are located. Our experience suggests that long-term missions in high conflict zones or remote areas are at a greater risk of exposing the local population to SEA. The rehatting of troops has also been identified as an additional risk factor. Rehatting is the transfer of uniformed personnel deployed by non-UN missions to a succeeding UN peacekeeping mission. Rehatting allows for a maximum number of uniformed personnel to be deployed in the field very quickly. However, the rehatted forces might not meet all UN standards at the time they are rehatted, even when member states are required to certify that the personnel they provide meets such standards ahead of their deployment with the UN. Some measures that have been taken to mitigate risks of sexual exploitation and abuse include, for example, better screening and vetting of personnel, providing adequate welfare measures for troops such as good rotation schedules, regular payments of salaries, inspecting bases regularly, strictly enforcing curfews, patrolling after curfew hours, monitoring access to local populations, and adopting non-fraternization policies. Efforts have also been made to increase representation of women among military personnel. Notwithstanding all these measures, however, we continue to receive allegations of sexual exploitation and abuse. So while the United Nations, the member states, civil society, others, unanimously agree that criminal acts of sexual exploitation and abuse cannot go unpunished, they have proven very difficult to prosecute. Why? There are a number of reasons. First, the allegations first have to be reported to the UN, and not every victim is willing or able to do so. Some may fear reprisal, may not be able to find adequate protection, for example, if they live in a camp for IDPs. Others who are struggling for survival may have become dependent on the goods that might have been given to them in exchange for sex, including water, food rations, and money. Some may fear that they would be stigmatized and ostracized from their own communities should these allegations become known locally. Other more vulnerable persons, such as children and persons with disabilities, may not have a sufficient support network to be able to bring forward their allegations to the UN. Once allegations are brought to the United Nations, the UN can initiate, in appropriate cases, disciplinary proceedings. However, the UN cannot initiate criminal proceedings because, as you all appreciate, the UN does not have any criminal jurisdiction over military or civilian personnel. Only member states have criminal jurisdiction over such acts. Depending on the category of personnel involved, the UN either has to rely on contributing states to investigate and prosecute their military personnel, or in the case of civilian personnel, it has to rely on the host state, where the legal system may not be fully functional for the reasons we described earlier, or the state of nationality of the accused to ensure criminal accountability. In order for criminal proceedings to be initiated in a member state, the UN has to share the allegations reported to it with the relevant national authorities. The victims, however, may not agree to the sharing of their personally identifiable information with national authorities. They may lack trust in the capacity of national authorities to entertain their allegations in an appropriate manner. The UN itself may also decide not to share the victims' information if it finds that there would be risks to their safety and security if it did so. Moreover, even once allegations are referred to relevant member states, the member states themselves may not be able to act on them due to their own jurisdictional limits. For example, some member states currently do not have jurisdiction over criminal acts perpetrated by their nationals abroad. Other member states may choose simply not to act on them, in which case the UN now follows up with them by naming and shaming the unwilling member states in his annual report on sexual exploitation and abuse. Now, I've mentioned that the UN's efforts to contain and eliminate sexual exploitation and abuse have continued now over a period of 15 years. But I'm somewhat heartened by three initiatives that have been taken by the new Secretary General, who began his service just in January of this year and who identified SEA as one of his initial concerns, even in the period when the interview process for the new Secretary General was being followed. The person who was eventually selected to be the new Secretary General had identified SEA as something that had to be more effectively addressed in the future. So what has he done so far? I would point to three things. First, in August of this year, 2 months ago, the Secretary General appointed a victims' rights advocate, Miss Jane Connors, who is an Australian national. The victims' rights advocate is a human rights expert tasked with advocating for victims' rights. She is serving in the Secretary General's office. She's reporting directly to him. Victims' rights advocates reporting to her will also be appointed in the field in those missions in which SEA has been a problem. And the appointment of this new victims' rights advocate and the field advocates has been well received by members of civil society, and I think it provides some basis for optimism that there will be a new focus on how do we ensure that victims receive the support that they need and that they're entitled to when they're the victims of SEA. A second step that the Secretary General has initiated is a voluntary compact, a kind of non-binding agreement with member states concerning solely sexual exploitation and abuse. So more than 70 member states, about now 3 weeks ago in New York during the high-level segment of the General Assembly, signed this voluntary compact. And I'm going to read 2 paragraphs because they're relevant in demonstrating that at least these states are taking on at the political level a commitment to address some of the problems that I've just been speaking about. First, the member states have committed, and I'm going to quote, "Take all necessary steps as available to apply disciplinary measures and/or undertake criminal prosecutions to hold nationals accountable for acts of sexual exploitation and abuse under the national legal framework, whether such acts involve UN civilian personnel that are nationals of the member state or personnel provided by the member state, and ensure that all such measures are enforced." End of quote. Then in a separate paragraph, the member states agreed to try to address this jurisdictional gap that I referred to, the fact that some member states' laws don't permit the prosecution. Here's what they said about that, and I'm quoting, "Work to remove existing obstacles, if any, to the criminal prosecution for crimes involving sexual exploitation and abuse committed by its nationals, including through consideration of legislative reform, if appropriate, including situations where culpable individuals have left their national service." So you see that if this compact is implemented in good faith by member states, we could see some progress in the prosecution of these cases. Finally, the third initiative is that the Secretary General has established a circle of leadership on the prevention of and response to sexual exploitation and abuse in UN operations. And this circle of leadership is open to heads of state and heads of government. And I'm pleased to note that Australian Prime Minister Turnbull has accepted the Secretary General's invitation to become a member of the Circle of Leadership. And these highly influential members of the Circle of Leadership are expected to use their high office to address the problem of sexual exploitation and abuse with a view to preventing and responding to such acts. So I think with these three acts, we have one which is operational, the appointment of the victim's rights advocate. That will all have effects both on the ground in missions where VRAs are appointed and also at UN headquarters. And then the compact and the Circle of Leadership, I think, are intended to ensure that member states at the highest level take seriously their obligations to prosecute these crimes. So I conclude now. Through this lecture, against the background of the evolution of UN peacekeeping mandates, I've attempted to sketch out a few legal challenges which the UN is currently facing. Of course, there are other challenges as well, and I know some of my peacekeeping colleagues from New York are here meeting with you this week to discuss some of these other challenges. These include more effective protection of civilians by UN peacekeeping missions, and also how peacekeeping missions can help find a lasting political solution to the conflicts in the countries where they're deployed. The United Nations is committed to addressing all these issues, the legal ones and the operational ones. In a broad way, the UN seeks to become more effective and more fit for purpose. I can assure you that the Office of Legal Affairs will do its part to achieve that. And in this regard, I know that we can also count on Australia's continued engagement with and commitment to UN peacekeeping. And I thank you very much for your attention.